In the previous section, we explored the use of the beneficiary deed under ARS, paragraph 33 on 405, as a means for property owners to transfer real estate automatically upon death, avoiding probate while maintaining control during life. This section continues that discussion by examining the various forms of property ownership and legal instruments that provide for automatic transfer of ownership to a surviving party upon death. These forms are essential for estate planning, helping individuals and families simplify title succession while ensuring property continuity without judicial intervention. Probate is the legal process through which a court validates a deceased person's will and oversees the distribution of their assets. While necessary in some cases, probate can be time-consuming and costly. Arizona law provides multiple ownership methods that bypass probate entirely by allowing title to transfer automatically upon death. These include joint tenancy with right of survivorship, JTWRS, community property with right of survivorship, CPWRS, and beneficiary deeds, joint tenancy with right of survivorship, JTWRS. Joint tenancy is one of the most common methods used to ensure immediate and automatic transfer of ownership upon death. In Arizona, this form of co-ownership is governed by ARS, paragraph 33, 431C. When property is held as joint tenants with right of survivorship, each owner has an equal and undivided interest in the property, and upon the death of one owner, their share automatically passes to the surviving owner or owners, completely bypassing probate. For example, if two friends, Anna and Brian, purchase a vacation cabin in Payson as joint tenants with right of survivorship, each owns an equal interest. If Anna passes away, Brian automatically becomes the sole owner by operation of law. No will, court order, or probate process is required to transfer title. To formalize the change, the survivor simply records an affidavit of death of joint tenant, along with a certified copy of the deceased joint tenant's death certificate. The key advantage of JTWRS is the avoidance of probate, but this ownership form must be clearly expressed in the deed at the time of acquisition. If the deed simply states joint tenants without mentioning survivorship, Arizona law presumes a tenancy in common, which does not include survivorship rights. Community property with right of survivorship, CPWROS. For married couples in Arizona, community property with right of survivorship, established under ARS, paragraph 33, 431B, is another powerful mechanism for automatic transfer. This form of ownership combines the equal ownership features of community property with the survivorship rights of joint tenancy. Upon the death of one spouse, the deceased spouse's share automatically vests in the surviving spouse without probate. For example, if John and Maria, a married couple, own their Scottsdale home as community property with right of survivorship, and John passes away, full ownership immediately transfers to Maria. She need only record a certified copy of John's death certificate with the county recorder's office to perfect her ownership. Beyond avoiding probate, CPWROs provides a significant tax benefit, known as the double step-up in basis. Upon the death of one spouse, the entire property's basis is adjusted to its fair market value at that time. This means that if the surviving spouse later sells the property, they may pay little or no capital gains tax, a major advantage compared to other ownership types. However, both spouses must agree to this form of ownership, and the survivorship provision must be explicitly stated on the deed. If omitted, the property defaults to regular community property, which does not include automatic transfer rights. Beneficiary deed. As discussed in the previous section, the beneficiary deed, also known as a transfer on death deed, allows property owners to designate one or more beneficiaries to receive the property automatically upon their death without probate, authorized under ARS, paragraph 33, 405. This deed functions similarly to survivorship ownership, except that the owner maintains full control of the property and can revoke or modify the deed at any time before death. The primary difference between a beneficiary deed and survivorship ownership is that the latter involves co-owners during life, while the former transfers title only upon death. This makes the beneficiary deed particularly useful for single owners or individuals who wish to avoid probate without adding another person to title during their lifetime. Comparison of probate avoiding ownership forms. These three probate avoidance mechanisms, joint tenancy with right of survivorship, community property with right of survivorship, and beneficiary deed, share the same goal but differ in structure and eligibility. Ownership type eligible parties. Transfer at death probate avoided key features. Joint tenancy with right of survivorship. Any two or more individuals. Two surviving owners, yes. Equal shares, requires survivorship clause. Community property with right of survivorship, married couples. To surviving spouse. Yes, equal ownership, double step up in basis. Beneficiary deed, any property owner. To named beneficiary, yes, owner retains full control during life. Revocable case. Example, Estate of Estelle, 1980. In re Estate of Estelle, the Arizona Supreme Court reaffirmed that ownership designation on the deed determines survivorship rights. The court held that because the decedent's deed did not include right of survivorship language, the surviving spouse was not entitled to automatic ownership, and the property had to pass through probate. This case underscores the importance of precise wording on title instruments when the goal is to bypass probate. Practical example. Consider a couple, Ethan and Sarah, who jointly purchase a home in Gilbert. Their real estate agent explains the difference between community property and community property with right of survivorship. To ensure Sarah automatically inherits the property without probate and receives the full tax benefit, they choose Sipawiros as their ownership form. Years later, when Ethan passes away, Sarah records his death certificate with the county recorder, and ownership immediately vests in her name. She does not need to open probate, saving time, money, and stress. Discussion. Which form of ownership allows unmarried individuals to hold property with automatic survivorship rights? Answer. Joint tenancy with right of survivorship, because it allows multiple individuals to share equal ownership and transfer property automatically to the surviving owner. Why might married couples in Arizona prefer community property with right of survivorship over joint tenancy? Answer. CPWROS not only provides automatic transfer upon death, but also offers a double step up in basis for tax purposes, minimizing capital gains if the surviving spouse sells the property. How does a beneficiary deed differ from survivorship ownership? Answer. A beneficiary deed names heirs who receive property only upon the owner's death, while survivorship ownership involves co-owners during the owner's lifetime. Review summary. Arizona provides several ownership methods that allow real estate to transfer automatically upon the death of one owner, avoiding probate entirely. These include joint tenancy with right of survivorship, ARS, Paragraph 33-431, which applies to any co-owners. Community property with right of survivorship, ARS, Paragraph 33-431B, which is available only to married couples and includes tax advantages. And the beneficiary deed, ARS, Paragraph 33-405, which allows property owners to designate heirs for automatic transfer upon death while retaining full control during life. Each method serves as a practical estate planning tool, ensuring title continuity, privacy, and efficiency in property transfers. For real estate professionals, understanding these distinctions ensures accurate guidance when advising clients on ownership structure and estate planning implications.